Okay, well, let me get started. I'm sure there'll be a few others who join us along the way, but just let me get started by covering what I'm going to be going through tonight. I will just spend a little bit of time talking about why I think compliance is important. There have obviously been changes to the way that notice is given to tenants, Section 8 and Section 21 notice. That has obviously changed a lot over the past months with COVID pandemic changes. There's new legislation I want to go through on breathing space, which is about debt moratoriums. There's electrical safety regulations. There are changes, still changes in place because of COVID in the Immigration Act, right to rent checks that we need to do. I'd like to talk a little bit about statutory periodic tenancies and why, as a landlord, you might be liable to pay council tax when you're on statutory periodic tenancy. I'll also talk about council tax obligations in terms of HMOs. We'll look at a little bit of recent case law which is relevant for landlords, and look at a little bit of existing legislation that hasn't changed, but there's a few tweaks and quirks to it that people may not be aware of, and it's good to be up to date on these things. In terms of regional stuff, I'll also be going through recent fines that landlords have been subject to because of non-compliance with the legislation. As I said, I'll talk about North Somerset and council tax being applied to HMO rooms. This is quite a recent development in North Somerset, but something that's been going on for quite a while with other councils as well. I'll also look at Bristol Article 4 changes that have happened in the last 18 months or so, and also a licensing update. There are changes afoot for licensing for rental properties in Bristol. And then also something that came up in the news just this week with Bath enforcing minimum energy efficiency standards. So we'll cover all of that, as well as having a look at what the future might hold for landlords and letting agencies as well in terms of managing properties. So yes, as I say, we'll look at the future. We'll look at the end of, potentially the end of Section 21, also where minimum energy efficiency standards, EPCs, are going, the regulation of property agents, and a potential bailiff amnesty over Christmas. Right, well, we've given people a chance to log on, so we've got a few people registered now. So let's get on and start getting into the content. And let me just say a little bit about who I am. My name is Ben Goldsmith. I run Goldsmith Property and have been for quite a while now. I've been renting property in Bristol for over 20 years now, just starting with one property and growing my portfolio. But I left my full-time job in 2013 and decided to focus on property full-time. And with my wife, we bought 18 properties in 18 months over the following year and a half. And we've kept most of those, and most of those have been HMOs. That's been the basis of our property portfolio. We've sold some and we've acquired some since then as well. But we've acquired approximately £5 million worth of property. And as I say, we kept most of them for rental income. I've done all sorts of different property strategies. HMOs was our main one, but we did buy some single-let properties as well. We've done title splits. We've taken larger properties and split them into multiple units and made profit that way. We've converted commercial properties, guest houses, pubs into HMOs. And then rented them out. We've done rent to rent. I've done a lot of serviced accommodation as well, although we've pulled back from that in recent over the last year actually. And now we're sort of focusing on managing properties for other landlords. So along the way, we've taken on rent to rent properties. We've taken on properties for landlords on a commission basis, and we're looking to expand that side of the business now. And I feel like as landlords, we know what's important to other landlords. And that's partly through experience of using letting agents in the past and being very disappointed with them. And, you know, I think we've learned as we've managed our own properties, we've made mistakes along the way, but I think we run a pretty smooth operation now. And I think importantly, we put compliance at the heart of of our lettings. It's really important, I believe, to stay compliant, and we'll talk about it in a lot of detail tonight, obviously. And I think what we look to do for our landlords is provide stable and hassle-free income for them. And we look to keep tenants safe so that landlords are safe from prosecution and everyone can sleep well at night. And we have happy customers all around. We have landlords who are happy because we get them good, stable income. We have tenants who are happy because they have good quality properties. And it's a win-win situation, really. So let me say why I think compliance is important. And I think ethically, we should comply with the law. It's there for a reason. It's there to keep people safe. It's about, at the end of the day, it's about health and safety. We need to keep our tenants safe and well so that they're happy, and our landlords are protected from prosecution. And obviously, the flip side is that if you don't stay compliant, there's a potential stick that you'll be hit over the head with. Bristol has a dedicated rogue landlord unit, and just Bristol itself has 3 significant convictions this year for where landlords have been fined £9,000, £87,000 and £330,000. And I'll go into a bit more detail on those a bit later, but that's obviously that last fine is pretty eye-watering in many respects, and you would not want to be coming on the end of that fine. But it's not just fines as well. Landlords who are not compliant can be subject to rent repayment orders from tenants or the council, and I'll be talking about rent repayment orders later. It can also mean that if you're not compliant, you're not able to serve notice on tenants, which can be a significant hindrance if you need to do that for whatever reason. And it can also mean that you're banned from letting property, so that if you want to rent property, you have to find someone else to do it for you. So there's a lot of good reasons why compliance is very important. Okay, so the first changes that I want to go through are serving notice. When I talk about serving notice, I'm talking about whether through Section 21 or through Section 8, getting a tenant to leave the property. So Section 21, often called no-fault evictions, it's just that you want the property back for whatever reason. Maybe you're selling it, maybe you want to move into it, maybe you want to renovate it significantly. Whatever the reason, you want to get the property back. And Section 8 notices are generally where there's been a breach of tenancy of some description. Maybe rent hasn't been paid, or there's other kinds of breach of tenancy agreement. So as of the 1st of October, we are back to normal on serving notice, which has been long awaited and fantastic for us. Now, when I say we're back to normal, I'm talking about England. Unfortunately, Wales still has pandemic limitations on serving notices. I think Wales is 6-month notices at the moment for Section 8 and for Section 21. They're expecting that to change at the end of December, but I don't think that's been finally announced yet. So hopefully you're not in Wales and that's not affecting you. But back in England, we are back to normal notice periods as of the 1st of October. So it's funny, it had been so long since we'd had normal notice periods that I had to go and double check what they were, particularly for Section 8, because they were, at one point it was 6 months notice under Section 8, which was a long time. Section 8 is normally a lot faster process. But so the notice periods are back to normal. For Section 21, that is 2 months notice from the date of service. So that's not the date you fill out the form, it's when it's deemed to have been served on the tenant. If that's by post and it's first class, it's generally, I think it's the day after or 2 days after. I normally give a few days leeway on the end of the notice period, just to give time for service. And with Section 21, there are a number of reasons why you will not be able to serve Section 21. So you can't serve it if you're in the first 4 months of the tenancy. You're also not allowed to serve it if the deposit is not protected. Also, if the prescribed information for the deposit has not been served within 38 days of receipt of deposit. And that's important. It's not 38 days of the start of the tenancy. It's 30 days from the receipt of the deposit. So sometimes that deposit will have been received a number of days, a week, maybe a couple of weeks before the tenancy starts. And you need to serve that prescribed information and the deposit protection certificate within 30 days of receiving the deposit. Also, if the property needs a license and you don't have one, you are not able to serve Section 21. If an improvement notice or an emergency remedial action notice has been served by the council on the property, because there are things that need doing to make the property safe, then you are also not able to serve Section 21 notice, and for a period after. And if you fail to provide a copy of the current EPC to the tenants, if you fail to provide a copy of the current gas certificate to the tenants, or if you're in breach of the Tenant Fees Act, if you've charged tenants fees that you're not allowed to, then there are also reasons why you're not able to serve Section 21. So Section 21 is the easiest type of notice to serve in some ways, because you don't need a reason for it, but it's also the most complicated in terms of all the documentation that you need to go with it, and all the hoops you need to jump through in compliance to be able to serve it legally. And if you did serve it and you hadn't done one of these things, then it would mean that when that gets to court, the judge would throw it out as invalid. So you'd have wasted your time and the court fees in getting to that point. So that's Section 21. Section 8, again, back to normal, thankfully, in England. And there are many grounds for serving Section 8 notice. I mean, basically it means there's been some sort of breach in the tenancy arrangements, a breach which is sufficiently serious to merit breaking the tenancy and evicting the tenant. And the most common one that is used is on rent arrears grounds. So if you've got 2 months or more rent arrears, you would often use the Section 8 route to evict a tenant, and each ground has a different notice period, and the notice period for 2 months arrears or more is 14 days notice from the date served. And you'd normally combine 3 grounds on a Section 8. You do ground 8, which is compulsory rent arrears eviction ground. You do ground 10, which is rent arrears, and ground 11, which is persistent delays in rent payments. And you'd file a notice using all 3 of those grounds. And the reason why Section 8 is better in some ways than Section 21 is that it's got a much shorter notice period, only 14 days. And you don't need to prove all that compliance that's involved with Section 21. If you can prove that when you serve the notice there's 2 months rent arrears, and if those rent arrears are still in existence when you go to court, then it's a compulsory ground for eviction. The judge has no discretion on his part, he just has to give the possession order. So as I say, those Section 8 and Section 21 notices are back to normal in terms of the periods. And just to let you know as well that the forms have changed again. They changed in, I think it was March this year, for breathing space requirements. They changed them again on the 1st of October. I think Section 8 and Section 21. So it's always good, if you are serving notice, to go onto the government website and to download the latest forms. Just make sure that you're not using an invalid form, and your notice won't get chucked out at the point you go to court. And the other thing to say that's happened in the last 6 months is that for quite a long time, bailiff evictions were paused during the pandemic. They started back up in June, and obviously there was quite a backlog to start with, many months of held up eviction processes. I've not had to do a bailiff eviction. I've only ever had to do one, and that was many years ago in London. So I'm not sure if those delays are still in place. But as I'm sure you're aware, the whole process of evicting a tenant can take many months. So it's good that we're back to normal notice periods in that regard. So are there any questions on notice periods? I know it did get quite complicated over the pandemic period, with lots of new requirements for notices and different notice periods for different types of sections and different grounds as well. It all got very complicated, but thankfully things are back to normal now. Okay, if there are no questions on that, then let me move on. Oh, so some tips on serving notice. As I say, there's lots of reasons why your Section 21 notice can be invalid. If you've not served all your documents needed for Section 21, then make sure you serve them before you serve the notice. So some of them, it won't stop you going ahead with Section 21 if you just serve them before you serve the notice. Others, it will make an impact, and we'll talk about some of those a bit later. With all of the documents that you serve, you need to be able to prove that you've served them. That's really, really important. So the system we use for managing our properties and for the landlords, we send any documentation through that system by email. We get documents signed through DocuSign electronically, and so we've got everything, all of our record of correspondence with tenants and documents that we've sent to them. It's all on our email system and easy to prove. So you need to be able to prove it. If you send it by post, you can get proof of postage from a post office. If you serve by, the important thing to say about serving by email, which we do, to do that successfully, you need to have in your tenancy agreement, your AST, that sending documents by email is permitted, a permitted way of serving documents, and tenants are required to tell you of any changes to their email address, and obviously their email address should be part of the AST too, so that you tie up all those loose ends, so that if they do change and don't tell you, then that's their responsibility. So yeah, there's just a few tips on serving notice if you have to. Now, breathing space regulation. This came into force on the 4th of May, and basically it's to help people who get into serious and persistent debt issues. And the idea is that when you are in debt, maybe you've been in debt for a long time, you can get pretty much weighed down by the need to keep making those repayments, and it's difficult to get a bit of clarity on how to get out of a persistent debt situation. So the idea is that this regulation will help people who are in a persistent debt situation to pause any debt recovery processes that are in place, to give them breathing space to just pull back and just think, how am I going to sort this debt situation out? So it's a time out effectively from their creditors, an opportunity to have some breathing space and find solutions for the person who's in debt. Now, there are two kinds of breathing space arrangement. There's a standard breathing space arrangement, and there's a few things to say about both kinds of breathing space arrangement actually. It's not just up to, let's take the example of a tenant, because that's the most likely example we're going to come across in a letting of a property situation. So a tenant can't just independently decide, I'm going to go into a breathing space arrangement, stop chasing me for the debts. They have to work with a debt advice provider who is authorised by the Financial Conduct Authority, and it's the debt advice provider who enters them into this breathing space arrangement. And as part of that process of going into the arrangement, the tenant will have to identify a list of debts that they have, and the debt advice provider will notify those debtors that the tenant is going into a breathing space arrangement, and this standard breathing space arrangement lasts for 60 days. And a person can enter one standard breathing space arrangement every 12 months. Okay. There's another kind of breathing space arrangement, which is a mental health breathing space arrangement, and it's the same in all but the following respects. And that is that for a mental health breathing space arrangement, it lasts for not 60 days as the normal one, but it lasts for the length of the treatment for the mental health issue plus 30 days. And there is no limit on the number of mental health breathing space arrangements that can be entered into. Now, obviously, people can suffer from mental health issues for months or years. So in principle, a mental health breathing space arrangement could last indefinitely. Some people never recover from their mental health issues. So that's a bit worrying from the perspective of a landlord who has a tenant owing them money. If they enter into one of these arrangements, particularly a mental health arrangement, there's no foreknowledge of how long that arrangement will last for, or how long they are not allowed to pursue that debt with the tenant. Now, it's not all bad news. So in terms of the consequences of the arrangement, while that arrangement is in place, we would not be allowed to pursue a tenant for debts, rent owed, which is at the start of the arrangement. So the arrangement will have a starting date, and a tenant will owe debts at that point. Once they're in the arrangement, we are not allowed to pursue them for those debts which were in place at the start of the arrangement. It's also the case that if that tenant is on a tenancy agreement with other people, let's say it's a husband and wife on a tenancy arrangement, and one of them goes into the breathing space arrangement, we cannot pursue the other people who are jointly and severally liable for that debt. So we couldn't, if the husband went into the arrangement, we couldn't talk to the wife about the debts. Likewise, if the tenant is a student and you've got a student tenancy with, let's say, 4 or 5 other students on the tenancy, if one of the students goes into a breathing space arrangement, we can't pursue the other tenants for the debts that are in existence at the start of that arrangement. We're also not allowed to charge interest or fees on the rent owed at the start of the arrangement, and we're not allowed to serve notice. We're also not allowed to contact the tenant to discuss the debt owed at the start of the arrangement at all. So we just have to leave them. We have got to give them a breathing space, and that's why it's called breathing space, you know. Now, there are some things you can do. You can pursue and contact the debtor for debts arising after the start of the arrangement. So there's an obligation, when someone goes into a breathing space arrangement, there's an obligation on them to keep paying their ongoing bills. And if they start accruing debts after they start the arrangement, it's legitimate for us to contact them about those debts. We can also speak to the tenant's debt advisor, and that's important because if the tenant fails to meet ongoing payment obligations, then the breathing space arrangement can be revoked. That's only for normal breathing space arrangements, not for mental health breathing space arrangements. But there will be a midway review, at which point the arrangement can be cancelled or continued. So if someone goes into a breathing space arrangement and they continue to not pay, we should be talking to the tenant's debt advisor and letting them know that they're not meeting their obligations, their side of going into that arrangement. So what it means for landlords, so as I said, we can't speak to tenants about rent arrears up to the start of the arrangement, and we can't pursue eviction based upon debts owed at the start of the arrangement. Okay. It's also worth noting that the Section 8 notice has been amended to include breathing space language. And as I said before, I mean, always go and download the latest version of Section 8 or Section 21 just to make sure that you've got that in there, because if you serve a notice which has the old language, then it's invalid. But what can you do? Well, you can pursue rent arrears incurred after the start of the arrangement. So if the tenant falls into arrears after that, you can talk to them about that, but you can't talk to them about the arrears beforehand. You can and you can also issue Section 8 notice if the new arrears exceed 2 months' rent. So if it's so normally under a normal arrangement, because it only lasts for 2 months, that's unlikely to be the case. But if it's a mental health breathing space arrangement, which could go on, let's say, for 6 months, if they exceed 2 months' rent arrears after they started the breathing space arrangement, then you can issue a Section 8 notice, because it's about arrears after they started. And also, and I put a little question mark here, but I think you can issue Section 21 because that's not debt related. But I have to say it's a little bit unclear, because as we saw previously, it says you can't serve notice. But Section 21 is not about debts. We haven't had, as far as I'm aware, a case come up in the court about this yet. So my reading of this is that because Section 21 is not debt related, you could serve it on a tenant under a breathing space arrangement. But I don't think anyone's 100% clear on this yet. We do already have a little bit of case law about breathing space. One important point that came out in the case was that breathing space does not affect people's credit score. There was so the case that went to court involved a guy called Breaks, who owed a lot of money, £500,000 to Guy, and he was entered into a mental health breathing space arrangement. And Guy wrote to the debt advisor and asked for the arrangement to be withdrawn, as he felt it had not been entered into in good faith. He felt that Brakes was doing this just to avoid paying the debt, basically, and using a mental health breathing space arrangement because it can last indefinitely. So the debt advisor refused, and Guy took it to court, and it seems that the High Court was very wary of setting what would have been a strong precedent in the first case on this new law and agreeing to the case. And they threw the case out, but they did say a few things. They said that the claimant should have provided more information before applying to court. So they didn't feel that Guy had really made the case very well, that the breathing space arrangement had been entered into in bad faith. But they were also very critical of the mental health professional, as no diagnosis was provided as part of the breathing space arrangement, and there was no idea provided as to how long the arrangement will continue. So effectively, they just said, you can't chase this debt, this £500,000 worth of debt, a lot of money we're talking about. You can't chase this debt for the foreseeable future until we say otherwise. And that is clearly not a very it's not a very good arrangement to be on the end of. Now, Brakes did try and add in new debts to the moratorium and said he would exit the arrangement and add new debts and then go into it again. But the court made it clear that this would definitely be in bad faith. So they effectively stopped him doing that. So that's the one case we have so far on breathing space. I think it doesn't give a huge amount of clarity, but yeah, hopefully we'll get some more cases which will give us a bit more clarity on how this will work going forwards. Are there any questions on the breathing space legislation? Has everyone heard of that before? Yeah. Okay, no questions. Well, if you do have them, then just pop them in the chat box, and if I don't see them right now, then I'll answer them later, okay? So, electrical safety standards. I still find landlords who don't realise that the legislation changed this year, and that now every single rented property must have an electrical installation condition report, electrical safety report, effectively. The only exception to this is where it's a resident landlord and you have a lodger arrangement, and only in the case where you're sharing facilities. If your lodger has separate facilities, then even in that situation, you would need to get an EICR, at least covering the electrics in the lodger's arrangement. So all new tenancies must have an EICR before the tenancy starts. That's important. And you have to provide it before the tenant occupies the property. Now, EICRs are issued for 10 years, but for the purposes of renting property, they are only valid for 5 years. And I think certainly the EICRs that I've had issued recently by electricians, they've just put the validity for 5 years. Even though they can issue them for 10 years, it's pointless because they're not valid for letting purposes more than 5 years. And it's important to get it right, because breaches can result in a fine of up to £30,000. It's important to note as well that it's not part of the Deregulation Act. So failure to comply on some of these issues, would not stop you serving Section 21 notice, because there's no breach of the Deregulation Act. And as I say, I'm still finding landlords who don't realise that this requirement is in place. Okay, we have a question from Sarah on breathing space. So I'm assuming that here of this breathing space law, so I'm assuming that a guarantor would not be liable for this debt. It's a good question, a very good question actually. My understanding is that, so let's take the example of a tenant who is in arrears, has gone into a breathing space arrangement, so we can't chase the tenant for those arrears. I guess the question is, can we chase the guarantor? Well, I think the same rule would apply in jointly and severally liable tenants. I think you're effectively, even though you're not chasing the tenant for that debt, you're chasing that debt, and that debt is protected under the breathing space arrangement. So my understanding would be that you couldn't chase a guarantor for debts of a tenant who is under a breathing space arrangement, unless those debts occurred after they've entered into the arrangement. Does that make sense? I hope that's what you're trying to ask. Okay, so let's go into the Immigration Act. So I hope we're all aware now that there's a legal requirement to check the right to rent of tenants. I'm sure we're all aware of that, but as always, the devil is in the detail. Yes, Sarah, I think you're right. Potentially the breathing space regulations is quite a severe law at the expense of landlords. And I think it remains to be seen how the courts interpret it, whether they are a bit more lenient towards landlords or not, but time will tell. So, Immigration Act, as I say, we are required to check the right to rent eligibility of tenants. Now, the legislation actually doesn't say tenants. The legislation says all occupiers aged 18 or over must prove they have a right to reside. And that's important for us as landlords and agents, in that it's not just the people named on the tenancy. Anyone who comes to live in that property, whether they're named on the tenancy or not, we have a legal obligation to prove their right to rent and right to reside. The law says that original documents must be presented face-to-face with the occupier. And there are two situations when you do this right to rent check. One is that you find that someone has an indefinite right to rent. So let's say they're a British citizen, they've shown your passport, that shows an indefinite right to rent. They're a citizen, they will remain a citizen, they can always rent from you. So there is no need to go back and ever check that tenant's right to rent again in the future. However, the other situation is that you have a foreign national who has a limited right to rent in the UK, a limited right to reside. Maybe they have a visa allowing them to work and live in the UK for 12 months or 2 years or 4 years. And so in that situation where they have a limited right to rent in the UK, there's an obligation on you to do follow-up checks on that right to rent. And the law says that the follow-up check has to be conducted at the end of their visa, their right to rent or reside, or 12 months later, whichever is the later. So it may be the case, and this doesn't make sense, but this is just the way the law is, so I'm just telling you. But if a tenant moves into one of your properties today and you check their right to rent, maybe they've got a visa which expires next month or even tomorrow or the day after. Even though you know that within a week, let's say, that tenant's right to reside in the UK has expired, you don't have to check it again for 12 months because the law says the end of the visa or 12 months, whichever is later. And 12 months is later than tomorrow if that's when their visa expires. So as I say, I know it doesn't make sense in some ways, but that's the way the law is written, and that's the way we have to check people's right to rent. Now, EU nationals have a slightly different situation in that they have an automatic right to reside in the UK for 6 months after entry into the UK. And they have to prove that right to entry by a boarding card for a flight into the UK, or a ferry ticket, or a train ticket on Eurostar. They would have to prove when they'd actually arrived in the UK. And again, you check that, and if they have a right to reside on the day that you check, then you don't need to check again until 12 months later. Okay, so even if they're showing you that they entered the country 5 months and 29 days earlier, they have a right to rent on the day that you prove that the day that you ask them to show their eligibility. You don't have to check for another 12 months. And as always, you need to keep evidence of these checks. So that's the law as it is with the Immigration Act. There's a couple of other clarifications to make. I did say before that you had to have a face-to-face review of eligibility documents with the tenant. During the pandemic, that was relaxed so that remote checks of documents could be done by video link or by email. And that was meant to expect that remote checking of documents was meant to end on the 20th of June this year. but that's now been extended to the 31st of March 2022. And after that date, we're back to face-to-face checking of documentation. And there was talk at one point as well that all of the remote document checks that we've done would have to be redone in person once we get to face-to-face checks again. Thankfully, the government backtracked on that, and there's no need to redo the remote documentation checks that have been done to date. Okay, a couple of other quirks to say about the Immigration Act. Right to rent documents and company lets. Now, with company let, you're obviously letting to a company, and you don't know necessarily what company staff members are living in your property at any one time. And in fact, the people they put in the property, they might change over time as they have different people working in the area or different consultants coming in. So it's important for you as a landlord that if you have a company let, that your company let agreement makes it clear that the company is liable for conducting right to rent checks on the occupiers of the property, and that absolves you of the responsibility. And make sure that the company has to do that. Also, if you're an agent and doing a let-only instruction for a landlord, it's important to make it clear that you're only checking the eligibility of the tenant at the point they rent the property, and the follow-on right to rent checks are the responsibility of the landlord. And finally, on subletting, I mean, generally landlords don't allow this. It can be a problem with their mortgage arrangements. But if your tenant sublets, and maybe he sublets without you knowing, it's important to know that for the purpose of this legislation, the tenant becomes the landlord and has the responsibility for checking the eligibility of anyone he sublets to. So you as the landlord don't have that responsibility. In terms of fines for violations of the Immigration Act, well, on this part of the Immigration Act anyway, there's an unlimited fine and/or prison for up to 5 years. Clearly, if it was a first offence, I don't think you'd be getting a £100,000 fine and a prison sentence. But for repeat offenders, I'm sure that those fines would increase as you repeated on multiple occasions, which obviously you wouldn't do if you've got any sense. Are there any questions on the Immigration Act and right to rent checks? I can come back to it later if you haven't typed it in yet. Okay, let me go on to talk about statutory periodic tenancies and council tax. Let me just have a quick drink of water first. So, many landlords are not aware of this, and luckily many tenants are not aware of it as well. And it's not unusual for landlords to let their tenancies run on from the assured short hold period and onto a statutory periodic tenancy. Many landlords do it, and I've done it in the past, and I will do it in the future, I'm sure. Well, with one exception, which I'll come to. The reason this is important is that when you go onto a statutory periodic tenancy, actually, you as the landlord are potentially liable to pay the council tax. Now, that is a bit of a shock for most landlords, because we assume that when a tenant is renting a property, they have the responsibility for paying the council tax. Now, the legal basis for this comes from two cases. There was a case called Superstrike v. Rodriguez in 2013, and it wasn't about council tax, that case, but what it did is it established that when there's a statutory periodic tenancy, what actually happens is that at the end of the assured, let's say you've got a 12-month assured hold tenancy, you have a 12-month tenancy, and then when you come to the end of that and enter the next month, this legal case decided that you don't enter a 13th month of the tenancy, you create a new tenancy at the beginning of that month. So every month on a statutory periodic tenancy, you're creating a new 1-month tenancy. Okay? So anyway, that was the finding, among other things, of that particular case. Now, a few years later, Leeds Council brought a case against Broadley, who was a landlord of 3 properties in the Leeds area. And a tenant had left a property before the end of their tenancy agreement. So, as far as the landlord was concerned, the tenant still had a liability to pay the council tax. But Leeds Council, because it passed on to a statutory periodic tenancy, Leeds Council argued that actually the landlord was responsible for the council tax when the tenant left early, and they pursued the council tax debt with the landlord. And this is because council tax is a landlord's responsibility on tenancies that are less than 6 months in duration. So going back to that case, Superstrike versus Rodriguez, that said that when you get on statutory periodic tenancy, you create a new 1 month tenancy every month. So actually, each one of those new months of tenancy, in principle, the landlord is responsible for paying the council tax on them, because it's just a 1 month tenancy each time. So the solution to this is very easy, and that is that there's a clause in your tenancy agreement which, rather than creating a statutory periodic tenancy at the end of the short hold period, you create a contractual periodic tenancy. And with a contractual periodic tenancy, the new month is added onto the existing tenancy. So at the end of the 12th month, you extend the contract, so it's now a 13-month tenancy. At the end of the 13th month, you extend it, so it's a 14-month tenancy. So you avoid the tenancy ever being less than 6 months. So it's easy. We've got language in all of our ASTs which make sure this is the case and make sure we'll never get caught out with this. But not many landlords know about this, and luckily not many tenants know about it, because in principle they could, whenever they go onto a statutory periodic tenancy, they could now go back to the council and say, sorry, but it's an SPT now. We're not liable for the tenancy. It's less than 6 months. Go and get the council tax from the landlord. So that's not a situation that you want to be in. So yeah, do make sure that your tenancy agreements create contractual periodic tenancies instead of statutory periodic tenancies, because you could get caught out by this and be liable for the council tax. Okay, there's been a recent case to do with the tenant fee ban, which it's worth updating you on. The case, in case you want to go and have a look at it, is Brennan v Ludlow Thompson. Ludlow Thompson being the letting agent, and there was a tenancy on the property for a group of sharers in a HMO, and as is not uncommon, they wanted to swap out one tenant and bring in another tenant, and the agency charged the tenants £394 for this, including £274 for the new AST. And the tribunal agreed that the amount charged was not reasonable. There is a cap in the law of £50 for this, and they argued that that cap should have been applied to the charge. And if the agent had wanted to charge more, they would have had to show there was a need to do something out of the ordinary, and that was not demonstrated in this case. So I think there's a few lessons learned. In terms of changing tenancies, I guess there are two kinds of changes that most commonly happen. One is a change of sharer, as in this case, and the other is an early termination, where you agree with the tenant that they can terminate their contract early. Now, with a change of sharer, clearly this case shows that fees must be capped at £50 plus VAT if you charge VAT. With early termination, it's quite common for agents and landlords to say, well, if a tenant wants to leave their contract early, if push comes to shove, I can just keep them to the contract, and they have a legal obligation to pay rent until the end of their tenancy agreement. Now, whether you'll get that rent is another issue, but there's that legal obligation because it is a contract you go into with a tenancy agreement. But often landlords and agents will agree to let tenants break their contract early, but there'll be fees associated with it. So where there's a reletting fee to the landlord, they will often require the tenant to cover that reletting fee and also pay rent until a new tenant is found. Now, the principle that courts tend to apply to this is that the landlord needs to not be at a loss because of the breach of contract. but also not to benefit from it. And therefore, I guess that way of normally approaching this is right to some extent. But the one thing I would say is that charging that reletting fee, let's say a 12-month tenancy has been signed for that group of tenants, and we're into the 11th month of the tenancy, it would be unfair to charge the full reletting fee to the tenant who wants to leave the contract, because the landlord would reasonably expect in a month anyway they'd have to pay a letting fee. So the concept is that you would have to pro rata that fee, that letting fee, depending on the percentage of the contract that was remaining, and that would be less likely to be thrown out by the courts. So I guess the other thing to say as well is that don't forget that if you do you want to avoid unfair fees to the tenant, illegal fees to the tenant, because you can get fined up to £30,000 for a prohibited payment, and obviously not able to serve notice, Section 21 notice, if you need to. So that is quite important. Are there any questions on anything we've covered so far? Any more questions? No? Okay, I will go on then. So I want to whiz through a couple of things here, just because these are not new laws. They're well established sections of the Landlord and Tenant Act, but it's things that a lot of landlords and maybe some agents as well are not really aware of. It's a legal requirement that the landlord's name and address must be provided on all demands for payment of rent, and this includes the tenancy agreement. So the tenancy agreement effectively is a demand for rent on an ongoing basis based on the tenancy, but the landlord's name and address also needs to be on any arrears letters. And it's important because if it's not on there, if it's not on those demands for rent, if rent is not legally deemed due if you don't comply with this. So what it means is the demands for rent are not legitimate, and therefore a tenant can't be seen to be failing to pay rent if a legal rent demand hasn't been served on them. So the address that has to be on there for the landlord can be a business address or a residential address, but not the agent's address. And Section 48 covers requests by tenants for the landlord's address. Well, as I say, it should be on the AST anyway, but they can make requests as well, and they must be in writing. And again, the address means a place of residence or business, and agents have a requirement to respond within 21 days. And just as well to say that if a landlord changes their address during a tenancy, then the tenants must be notified, and if they're not notified, then any Section 8 or Section 21 notices are not valid. Again, that's a little known peculiarity to the law, but you don't want to get caught out by that if you do serve notice and then find out you haven't informed tenants of any change of address. So I'm losing my will to speak here. Minimum energy efficiency standards. So as I'm sure you're aware, as of April 2020, all rental properties have to have a minimum EPC rating of E or better. Now, exemptions are available for certain circumstances, but in general, properties have to have that E rating. And you cannot market a property without an EPC. So you can't put a property on the market to sell if it requires an EPC and you don't have one. And likewise for rental, if a property requires an EPC and you haven't got one, then you can't market the property for rental either. Now the plan is that by 2025, all rental properties will have a C rating or above. I think that's going to be incredibly difficult on some properties, particularly the old Victorian properties, of which I love buying because they're great properties and often quite spacious, and they make good HMOs. I think there's going to be awful challenges and problems in making that happen. That is the declared intention of the government. Obviously, it's a few years away, and I'll talk a little bit more about preparing for that. But I think we need to look out. I mean, hopefully the government will either backtrack on that or make a reasonable list of exemptions or help people out to meet those requirements where it will be exceptionally expensive to do so. Now, there are a few quirks to do with EPCs. If an EPC expires midway through a tenancy, there's no actual need to renew that EPC at that point. It's only required at the start of the tenancy to market the property and to give to the tenant before he enters into the tenancy agreement, before he moves in. So there's no need to renew it if you don't have to or don't want to. And one of the reasons why this is important is that in principle, and actually as demonstrated by case law, HMOs do not need EPCs. And this has gone to court where someone was seeking possession from a tenant in a HMO. And the tenant said, well, I was never given an EPC, so your Section 21 notice is invalid. And the judge found that actually for HMOs, EPCs are not required because the tenants are not paying we're not paying the utility bills, and therefore the fact that the tenant hadn't been served an EPC did not stop the validity of the Section 21 notice. So there is a question to be asked: if you have HMOs, should you even bother getting an EPC? I mean, if you've got an EPC, then there's a requirement to comply with these standards. To comply, I mean, let's be honest, you should have at least an E rating. But if you don't need to get an EPC and you don't get one, then you cannot be forced to comply with a C rating for your property. So, it has me asking myself whether I should keep my EPCs for HMOs up to date, because if I don't, then I don't have to comply with that C rating. Because if a property doesn't have an EPC and doesn't require an EPC, then they cannot force you to comply with energy efficiency standards that you don't know about on the property because you don't have an EPC on it. Anyway, it's an interesting point, and if you do have a HMO, then it's worth thinking about, especially if you know that it would struggle to meet that C rating. Okay, I mentioned rent repayment orders earlier. These were brought in the Housing Act of 2004. So they've been around for quite a long time, but they're increasingly being used, and they can be applied for by tenants and by councils. And tenants can apply while they're residing in a property, or for up to 12 months after the offence took place, which led to them claiming a rent repayment order. And tenants and councils are allowed to claim up to 12 months rent is repaid. It's worth noting that in rent-to-rent situations, the superior landlord can't be pursued. It will be the rent-to-rent operator who is pursued. And it's also worth saying that on average, awards are being made of between 75 and 80% of the rent claimed. So obviously that can be a significant amount on 12 months rent. And it's worth knowing what they are and avoiding if possible. So what are the grounds for getting a rent repayment order? So tenants can apply for a rent repayment order if any of the following apply. If the landlord has used or threatened violence for securing entry into the property, if there's an illegal eviction or harassment, and obviously harassment is very open to interpretation. Also, if there's a failure to comply with an improvement notice under Section 30 of the Housing Act, or a failure to comply with a prohibition order under the Housing Act, both of which would be served by the council, or if there's a breach of a banning order on letting properties, or if the landlord has control of or manages an unlicensed property or HMO which requires a license. So in any of those cases, tenants can request a rent repayment order of up to 12 months. And tenants are increasingly aware of these rights and consult with the Citizens Advice Bureau, who are also aware of these rights and regularly inform tenants about them. And I think, we're also seeing solicitors now advertising their services in applying for rent repayment orders, and I believe there are even some solicitors which are offering no win, no fee cases when it comes to rent repayment orders. So increasingly people are aware of this. It could be quite a significant amount you would have to repay. So do make sure, again, that you comply. The consequences can be quite severe. Now, gas safety. We all must know that properties have to have a gas safety certificate. The basics are clear for everyone. We have to have them every year, and not just anyone can do it. It has to be an accredited gas safe engineer. And what does it need to cover? Well, the boiler is obviously the one that everyone knows about, but if there are any other gas appliances in the property, then they need to be covered as well. If there's a gas fire, which I know is quite unusual in tenanted properties, but more likely might be a gas cooker, then that has to be covered by the gas safety certificate as well. Now, if a tenant brings a gas appliance into the property, there's no legal obligation. Oh, and the other thing, sorry, that has to be covered is the flue from the boiler. So it's not just the boiler itself, but the flue has to be covered by the gas safety certificate to make sure that the waste gases from the boiler are being disposed of safely for people inside the property, but also people outside the property. So if a tenant brings a gas appliance into the property, so let's say you provide an unfurnished property with no appliances, if they install a gas cooker, it's not legally your responsibility to get that covered by the gas safety, but I think for the sake of adding that into what the gas safety engineer is already doing, it probably makes sense for you to get that covered by the gas safety certificate as well. Now, when can you get the gas safety done? So they last for a year, and in times gone by, landlords would leave it to the last minute to get it redone, because it only lasted from the date that the certificate was the date the gas engineer went to do the inspection and test the gas appliances. So if you did it too early, you'd be missing out, you'd be losing out every year. But I can't remember when it was actually, but the legislation has been changed now so that you can renew a gas safety certificate up to 2 months before it expires, and the new date of expiry will be 12 months from the current gas certificate's expiry. So, for example, if we were on if you have a gas safety certificate that expires on the 1st of January, I could get it now renewed, and it would still be valid through to the 1st of January 2023. Okay, so within 2 months of expiring, you can get it renewed and still keep that the 12-month duration on it. And you also, when you get a gas safety renewed, you have a legal obligation to provide the tenant with a copy of it within 28 days of renewal. And in terms of the penalties for not complying with gas safety, failure to comply is a criminal offence, and it has an unlimited fine and/or 6 months in prison. So it's a pretty severe penalty that can be applied. It also means that you can't serve Section 21 if you've not given tenants a copy of the current certificate, or, as we'll see in a second, if you haven't given a gas safety certificate prior to them moving in. And it is considered to be a hazardous situation if there's no gas safety, and it means that the council can impose an improvement notice or a banning order on you, requiring you to do works, as in get the gas safety done. There are a couple of cases which are of interest. The first one, Assured Property Services versus don't ask me what that name is, I have no idea. In this case, the gas safety was not provided to the tenant before occupation, and the court found this breached the Deregulation Act 2015, and the Section 21 notice that was served was deemed to be invalid, and the tenant was awarded costs as well. So in this case, a gas safety had not been provided to the tenant before occupation. Now, in the second case here, again, the gas safety was not provided to the tenant before occupation, but it was issued to the tenant, but it was given 11 months later and before the Section 21 notice was issued. And again, the judge did not accept this as sufficient and refused the possession based on Section 21. The Cardigan property did appeal it, and it was upheld at appeal. So yeah, they failed their appeal. So it's important to note that this shows that you have to give that gas safety certificate before a tenant moves in. If you don't, then even if you serve it later, Section 21 notice will be invalid. So very important to comply there. Are there any questions on what we have so far? No? Okay, let me crack on, because I know that we've got going quite over on time. Accidental HMO landlord. So I think this is not unusual for this to happen, and I think it comes down to a failure to understand what is a HMO. So a HMO, a lot of people think a HMO is 5 or more people from 2 or more households, but that's not. That's mandatory. That's a mandatory licensed HMO. Actually, a HMO is any property where there are 3 or more people from 2 or more households. So there could just be 3 people in property, and that's a HMO. But most councils don't bother licensing small HMOs which have 3 or 4 people in them. So you could become an accidental HMO landlord by having a normal buy-to-let property where they have a couple living in the property and a friend moves into another room, and that becomes 3 people from 2 or more households, and it becomes a small HMO. Or you could have 2 non-related couples living in a property, and one of them has a child, and now that's 5 people from 2 or more households. And now not only is that a HMO, but it's a mandatory licensed HMO. So I guess this comes down to the fact you need to be fully aware of who's living in your property. You should be doing regular inspections and looking out for additional sets of clothes and sets of shoes that appear in the property, in addition to the people you know are living there, because it could be the sign that someone's moved in on a permanent basis. And if that's the case, then it could impact whether you're running a HMO. So why does it matter? Well, in the second case I gave, where there's 2 couples, one has a child, now there's a mandatory licensable HMO, and failure to get a license for that is a serious offence. Even in the other case where a couple has a friend come and live with them, if a council has additional licensing, then what they're actually saying is every HMO, no matter how many people live in it, has to have a license. So again, you could be in violation of licensing regulations, which can lead to unlimited fines. And it's important as well because different standards apply to HMOs. And the most obvious one is fire alarm systems. So HMOs generally require additional fire safety mechanisms to be in place. It's also important because if you've got no license, you can't serve Section 21 if you need to. And as I say, there's potentially an unlimited fine for operating a non-licensed property, rent repayment order opportunities for tenants in the council, and you can get banned from letting property as well. So you don't want to be in that situation. So always know who's living in your property. You know, a friend coming to stay for a week or 2 is fine, but if it becomes their primary point of residence, then whether they're on the tenancy agreement or not, they're considered an occupier, and therefore it can make it a HMO. Right. So I did say I'd go through a few convictions recently. We're seeing an ever-increasing number of convictions against landlords. We've got from South Gloucestershire here in October 21, £7,000 for operating HMO without a licence and Category 1 hazards in the property. In Bristol in April 21, poor conditions across 3 properties, leading to £30,000 fine. North Somerset, failure to improve property conditions, £15,000. Illegal eviction, £2,000, and the person was tagged with a curfew of 7 o'clock at night to 7 o'clock in the morning. And this one, I mean, in Bristol in March 21, a property company was fined for violations across numerous properties. They were fined £330,000, a massive amount. And it's for poor management, overcrowding, disrepair, no fire alarm system in one property which had many, many people living in it. So really serious violations, and quite frankly, they got what they deserved. But yeah, the point is that councils are increasingly active in in going after rogue landlords and going after properties that are not compliant. So as landlords, we need to be on top of the legislation, and I hope tonight is helping with that, and make sure that we comply with it, because the consequences can be really severe for us. Sarah, I'll come back to that question at the end, if that's all right. Right. I'll update you on something which is having an impact on me at the moment, and that is that North Somerset Council have decided to start going after HMO rooms and apply council tax to the individual rooms. I've actually had this on a property of mine, which is a converted pub. It has an 8-bed HMO upstairs and a 6-bed HMO downstairs. We have up to now been paying 2 council tax bills for it. And in August this year, they didn't tell me, they just decided to change the banding, and they wrote to the tenants and told them that they'd be billing them on a room-by-room basis. And so now there will be 14 council tax bills for that property, and it changes the council tax liability from £4,000 a year to £18,000 a year. So a massive change. And obviously that has huge implications as well, which I'll come on to. And obviously, since this has happened, I've been digging into what the basis for doing this is, because the rooms in this HMO, they're all en suite, but none of them have cooking facilities, so they're not self-contained. And I'd always considered that if you make a room self-contained, that's when you risk having a separate council tax banding. But all of these rooms, none of them have kitchen facilities in there. They all have to use shared communal kitchen facilities and lounge facilities. So anyway, there are copious amounts of council tax practice notes online, which are mind-numbingly boring, but obviously they are what I've been reading recently to try and work out how to deal with the situation. And they do say some interesting things. And about HMO rooms, they say that despite not being self-contained, these units would form a separate hereditaments. Each unit would have required a separate band to be attached to it. So clearly laying the groundwork there for room banding. And they talk about a type of dwelling, one defined by occupation only, where it doesn't have to be self-contained in the sense of having all necessary facilities, and where rooms are separately let and a landlord has relinquished paramount occupation, multiple dwellings will exist within a larger self-contained unit. Now, I have to say this is really complicated, and the valuation office agency who do these bandings are reading the various and conflicting regulations and laws in a way to suit them, and I think it comes down to a number of issues. So they make it clear in their practice notes that there's 2 kinds of properties. There are properties which are constructed for the purpose of being a single dwelling, so a house, but maybe that house has been turned into a HMO. And in that case, they're saying that generally those properties will maintain a single banding for council tax, so 1 council tax for the entire property. But where a property has been constructed specifically for multiple occupation or converted with significant alterations for multiple units of occupation, then generally bands will be attached to each unit of occupation, as in each room. So that gives a little bit more clarity. I talked about the issue of self-contained, and I think that the greater your room can be considered self-contained, the more likely this is going to be applied to you. I don't think that necessarily not having ensuite facilities might vaccinate you from this. Sorry, I couldn't think of another word to use than vaccinate, but stop that being applied to you. But the less self-contained you are, the less likely I think this is going to be applied to you. Now, we did see this phrase just before in the definitions that I over the page. Hereditaments is a key concept in council tax, and it's really unclear what it means, to be honest with you, in law. There was even a ruling which said that the understanding of hereditament in the law is confusing and contradictory, But it comes down to what they call ratable occupation. So actual occupation of the room, exclusive occupation of a property or room, a beneficial occupation, and an occupation that's not too transient a period. And I'll come back to why that might be important in a second. But basically, if any of those are missing, then it will not be a ratable occupation, as in that room won't be a ratable occupation, and they'd be more likely to charge council tax on a property as a whole. And I think it's interesting as well to look at the common law definition of hereditamент, which is any kind of property that can be inherited. Now, HMO can't be inherited. That's ridiculous to consider that a HMO room can be inherited. You can't sell a HMO room. It has no value. You can't inherit it. So I think there's some clear contradictions here. Now, the fact is that we don't quite know where this is going to go. This is not a new thing. There have been a few councils which have been trying to do this for a while, and I think councils are seeing this as a potential money-making opportunity. As you can see, they've turned a council tax liability of £4,000 into potentially £18,000 a year. That's a massive increase. And this approach is being challenged from within the property community. So I'm part of a group which is putting some money towards challenging this. We've grouped together some funds to employ a council tax expert in this, and one of us is putting a test case forward to the VOA tribunal to hopefully establish a precedent which says that that this is not the way to go about things. That where units are not completely self-contained, they shouldn't have a separate council tax bill applied to them. But we're still waiting to see where that goes, and it may take some time for that to be resolved through the tribunal. And I guess, well, why should we be concerned about this? Well, it may not be happening to you at the moment. It may not be happening to your area, but believe me, if councils start legitimately changing council tax liabilities of £4,000 into £18,000, then other councils will flock to this. So we do need to be aware of it, and I think we can't afford to bury our heads in the sand on this. The interesting thing is that the VOA has clearly stated that where council tax is applied to HMO rooms, it's not the landlord's liability to pay it. It's the tenant's liability. So it's a little bit of a silver lining there for landlords. But the reality is, it's going to impact that room in a number of ways, because tenants are not expecting to have £100 extra added to their rent, which effectively it would be. We'd also have to be clear about what your wording is in your language for tenancy agreements, because many of you will have put in HMO tenancy agreements that the landlord pays the bills. We don't quite say that. We say that we'll pay the property bills. And for example, in there it says that if you want to put a television in your room, then we're not going to pay for your TV license. That's your responsibility in your room. We would apply the same principle to the council tax bills. We'll pay property bills, but we won't pay room bills. And if council tax is going to be applied on a room basis, then I think we've got strong grounds to say that's not covered by our tenancy agreement. But it's going to effectively mean that it'll cost more for tenants to stay in these rooms, if not in the rent itself, then in the additional cost of the council tax bill, which will mean that we'll have to reduce rents to compensate for that, either partially or completely, or we will risk getting voids. We'll risk getting tenants who can't afford to pay. We'll risk more evictions from rooms. And let's be honest, what really annoys me about this move by the councils is that it affects the people who can least afford it. So the reason people are in HMO rooms is not necessarily because they love living with 5 transient people who can change on a month-by-month basis. Ideally, they'd want to be living in their own flat or their own house, but they can't afford to do so. So these are the people in the private rental sector who have the least money, and it's going to hit them the most. And it's going to also lead to some landlords removing their HMOs from the market, because it just doesn't make any financial sense for them. So if they remove the HMOs from the market, maybe they change them into a different use, maybe they change them into flats, but it'll reduce the availability of rooms, which again will put rents up because there'll still be the same demand but less supply, and again it's going to hit the people who can afford it the least. So I think it's really important that we fight against this. There is if I come to this, there is a petition that you can sign. I didn't want to put the whole link in here because it's quite long, but if you search Parliament petition then 596175, you'll find the petition that's been submitted to Parliament on this issue. Please go and sign it. Let's get past the 10,000 threshold, so this has to be responded to. Share it as well. Tell people about it. Get them to sign it as well. Now, I think from what we've learned so far, there are a few tips that we can give you in ways that if you are operating HMOs, ways that you can try and avoid having council tax liability. Do not put kitchen facilities in your HMO rooms. I think that's a dead cert. You're going to probably get council tax on the rooms then. Also, when we talked about what hereditament meant, it was about exclusive access. If you can start providing services in your rooms which require access, so I'm sure you've probably got a cleaner that goes into your HMO anyway. If that cleaner also goes in and cleans the shower room in the tenant's area, in their room, their ensuite room, then you can make an argument that actually the tenant doesn't have exclusive access, that you're going in and providing services. You can undermine one of those key foundations of a chargeable hereditament. Another way might be to have a shared AST for the property. So like on student lets, where they all sign a tenancy agreement, it's one tenancy agreement. I think that's good grounds for saying actually it's being dealt with as one property, one tenancy agreement, therefore one council tax bill. There are reasons why tenants may not like that, but that might be one way around it. And another suggestion is that with your AST you have a plan of the property showing the bedroom as exclusive access and the shared communal and the other areas as shared access. So you're making it clear that there isn't exclusivity overall on the agreement. There are some areas of shared access, and I think the other idea is that if you can have different types of tenancies and shorter periods of occupation, maybe ASTs, but also sometimes rent rooms out for 2 months, 3 months, 4 months on a license to occupy, then you can again make the argument that actually it's a more transient form of accommodation for people, which again undermines, if we go back to the definition of hereditament, it's about this occupation is not for a transient period. If you're getting lots of shorter tenancies in there or shorter licenses to occupy, then it undermines this rateable occupation, and it means that actually it wouldn't be appropriate to apply council tax by the room. So there's the update on HMO rooms and council tax. Not a good update, I'm afraid. I will keep people updated on what's happening. I do run a property group on Facebook. It's called Bristol Property. If you sign up to that, you can see updates as I go through this process. And what happens if you do get this applied? Initially, you need to challenge it with the VOA. And if they don't change their decision, then you can take it to the Land Tribunal, the VOA Tribunal, and formally challenge the application of room banding there. And that looks like that's what I'll be doing in the coming months. I will quickly whiz on from this. Bristol has a number of areas where there's Article 4, so it stops you changing a property into a HMO. They expanded these areas in June 2020. It used to just be around the university, around Clifton. I forget exactly where it was, but it's expanded much larger now, up north into Horfield and out to Fish Ponds and Eastville, out to St George, around to Barton Hill, Bedminster. And what that means is that you can't just change a house into a HMO without going through the planning permission process. So any HMO that you want to create there that was formerly a family house has to be done using planning permission. licensing in Bristol. I talked about mandatory licensing. Any HMO with 5 or more residents across the country has to be licensed. Additional licensing is where councils say, actually, we want every HMO in our area to be licensed. So even 3 and 4 occupant HMOs, we want those to be licensed. And Bristol set up additional licensing in July 2019 in 12 areas, and they're also looking to extend this into Bedminster, Brislington West and Hallfield in the coming months. They've just finished their consultation and report on that. There's also selective licensing, where the council says we want every single rental property to be licensed, and there's been a few areas where that's been applied, and as I say above, Bedminster and Brislington West, they're looking to do that, and generally it's because they feel that the quality of rental property in those areas is really bad, and licensing means there'll be inspections, there'll be standards to comply with, and it will bring the quality of the rental property up. So it's in these areas, it's a criminal offence not to have a licence, and as we've talked about, you can have a rent repayment order, ban from letting property, unlimited fines, and it can invalidate your Section 21 notice. So these are the areas where there is currently additional and selective licensing. So in all of the highlighted areas, there's additional licensing. So if you've got HMO there, you need to have a license for it. And the pink areas, they've got selective licensing as well, where any property needs to be licensed. And a final thing just to update you on, Bath have a policy put to Cabinet on the enforcement of energy efficiency regulations. They're looking to actively find and prosecute properties which don't meet the minimum EPC standards of E. So they're looking to pass that policy in the Cabinet and then go after rogue properties, force them to make improvements and fine landlords £5,000 if they don't do it. Quickly, a little bit about the future. In the Queen's speech in April, it was announced that Section 21 eviction proceedings would be abolished, and that would include reforms to Section 8. This has now been delayed until next year, and it is important because I think we'll need to see considerable reforms to Section 8 if that happens. We talked about Mies, about EPC standards getting to C for rental property. The other big change that's in the pipeline for the future is the regulation of property agents. We've seen this in Wales over the past few years with Rent Smart Wales. It's a way of regulating everyone who's involved in letting and managing property, so agents but also landlords, and it will probably require that anyone involved has to go through significant qualifications standards, and it's probably going to apply to landlords as well, but we're still yet to see the details of that, and hopefully more details will come out soon. So just to wrap up, really, compliance is I hope I've shown how compliance is really, really important, and if you've got any questions, then please do put them in the chat box now if you want to, or send an email to me and I'll try and answer. Join the Bristol Property Facebook group. It'd be great to see you there, and I'll be updating. I always provide lots of updates on legislation and tips and what's going on in the region. If you want to get a compliance health checklist, then you can go to www.resources-goldsmith-property.com/compliance health check, and that gives you that lets you go through and do a full health check on your property and your tenancy to make sure that everything is in order with it. It's always good to know if you're non-compliant in some way so that you can fix it. And if you want to get updates from Bristol Council, then please email that email address with the word subscribe, and they'll add you to their mailing list. Now, Sarah, you asked about 2 lodgers, and I have forgotten what that was about now. I've forgotten what it related to. Are you still there, Sarah? Could you put in what the question related to? If not, I'll contact you after the webinar, and I can try and clarify for you. I think it was about, that's right, becoming an accidental HMO landlord. Yes, That's right, living with a family. So it doesn't apply when the landlord lives in the property. That's a different arrangement. So two lodgers, well, okay, I'm not sure. You're saying two lodgers living with a family. If you're talking about a landlord living in the property, they can have two lodgers. That doesn't make it HMO. It's a completely different arrangement when the landlord lives there. Obviously, there is a limit to the number of lodgers that a landlord can have. I can't remember if it's 2 or 3. But yeah, the licensing requirements don't apply in that situation. So I hope that clarifies. Okay, well, great. Look, I've gone on for an hour and a half. That was quite long, longer than I thought. I hope that has been useful. And if you do have any questions, then please do contact me, and I will try and help. And I will be sending out a link to a recording of the webinar if there's something that I glossed over a bit too quickly for you, so you can go back and you can listen to it all again. Wouldn't that be fun? But yeah, anyway, thank you very much for making time for me tonight. I hope it's been useful.